meeting. Hello, everyone. Welcome. My name is Jessie Baker, and I'm a portfolio manager with Camco. I would like to remind everyone to please stay muted while the presenter is speaking. You are always welcome to place any questions you may have in the chat. This meeting is being recorded and will be posted on the company's website and YouTube channel. I would like to introduce Adam Marcus and Robert Costello with Marcus and Hoffman. They will be presenting on the topic of enforcing rules consistently, conflict resolution, and dispute management. Adam or Rob, you may now begin.
Great. Thanks so much, Jessie. So my name is Adam Marcus. I'm here with my colleague, Rob Costello. And as Jessie indicated, we're with the law firm of Marcus and Hoffman. We have the pleasure of representing about 350 community associations throughout southeastern Pennsylvania. We have 9 attorneys, basically all of whom specialize in community association representation. So we are here this evening, as Jessie indicated, to talk a little bit about consistent enforcement of rules and regulations, conflict resolution, dispute management in condominium and homeowners associations. And we have a little presentation that we're going to go through, and then we have time at the end for questions and answers that you may have. So the main topics that we're going to talk about, basically just give an overview of rules and regulations, just that you understand. I mean, it sounds pretty straightforward as to what it is, but sort of understanding some of the nuances of it. Consistency in drafting and enforcing rules and regulations, some best practices to avoid the inconsistent enforcement, which is really probably the most critical thing we'll talk about this evening, some conflict resolution, dispute management, and then ultimately the steps to resolve conflicts and manage disputes within your association before the Q&A. So, rules and regulations. So I guess at the outset, it's just important to distinguish what a rule and regulation is. A rule and regulation is not something necessarily contained within the declaration of bylaws. It's something that the association separately adopts by way of the board of directors, and we'll talk about that process. But if you think about your declarations, they typically have a set of use restrictions within them. That's a sort of old school, but very typical for condo docs to have specific things that say you can't have awnings or commercial vehicles, whatever it would be. And when it's in the declaration, it has a pretty powerful piece because it's in a recorded document versus a rule and regulation. So it is important to distinguish them because the standard under which they're reviewed is actually quite different. The rules and regulations that you ultimately adopt, and it could be a whole host, it could be sort of scattered all over, but you put them all together, it makes a part of the community's documents. You have the declaration, the bylaws, and the rules and regulations. We consider all 3 of those a part of the docs, and we'll talk about the hierarchy. Generally, I'll just go back one sec, sorry. Oops.
There we go. Got it. All right, we're good.
Okay, so rules and regulations generally are an addition, just to be clear. They are an addition to things contained within the governing documents. They are subject to greater scrutiny because they are subject to the board of directors' abilities to essentially adopt, amend, and repeal them from time to time. So boards have a lot of discretion. And because of that, they're subject to a greater scrutiny than what would be contained within the bylaws of the declaration. Go ahead, Rob. Thanks.
Yeah. Okay. So as Adam indicated, the rules and regulations are part of the governing documents, but I always find it helpful, when you're talking about any of the governing documents, there is kind of a hierarchy, an order of them. So the recorded declaration, that's your primary governing document. Generally speaking, the terms in the declaration cannot be revised or altered without the affirmative vote of at least 67% of the association's unit owners. Number 2 in line, you have the bylaws, or depending if you're an older, a condominium community, code of regulations, generally governs the internal workings of the association, how the board is supposed to operate, things like that. Again, usually cannot be revised or modified without the affirmative vote of at least 51% of the association's unit owners. So as Adam indicated previously, the rules and regulations are a little bit different. Not only do they, add additional requirements or restrictions, any of those additional requirements or restrictions are established and added by the board without having to get, prior unit owner approval. Which again is one of the reasons why it's under greater scrutiny, is because the board is the body or party, adopting those rules and regulations, and the unit owners aren't voting on them, when they're getting implemented. Also, the rules and regulations, cannot be in conflict with either of the other two governing documents. I think this is you.
All right, so authority to adopt rules and regulations. So there is generally great authority for adopting rules and regulations for homeowners and condominium associations, and actually co-ops as well. It's built into the acts. So the acts specifically give board of directors, well, it actually identifies it as a power of the association, but a subsequent provision identifies that essentially all powers of the association, unless otherwise provided to unit owners, fall and rest with the executive board. So it is statutorily provided, and then typically it's also provided within the governing documents. Most governing documents that we have for the 350 some odd associations all have provisions that give the board of directors the right to adopt, amend, and repeal rules and regulations. So the authority is fairly strong for boards to be able to do it. As Rob indicated in the last slide, though, you cannot adopt a rule and regulation that would be in conflict with either the declaration or the bylaws, because those documents would always prevail, or state law. So why adopt rules and regulations? There's a lot of different reasons why community associations adopt rules and regulations. One is to preserve the aesthetics of the community, right? So maybe you don't want one house that's purple, one house that's pink, one house that's yellow, one house that's blue. I mean, that may not be the aesthetics that the community is looking for, because ultimately, one of the primary roles of the board is, I mean, aside from, looking, basically the board's job is to act in the best interest of the association, and often acting in the best interest of the association is enhancing and protecting home values. And one of the ways that that can be accomplished is through identifying and adopting rules and regulations that help keep the aesthetics of the community in a way that does help enhance and protect that. It's also done to ensure that the terms and conditions in the governing documents are adhered to. Sometimes, the governing documents may talk about something, but it doesn't really provide greater detail as to how it's done. It says, for example, you could have a provision that says you can't do something. Great. Well, what's the enforcement mechanism? So you need a fine enforcement policy, a rule and regulation that delineates a very clear way of going about doing it. Or it may say commercial vehicles are subject to board approval. Well, you don't typically want things too discretionary, because that creates issues that we'll talk about in terms of selective enforcement. So you may want to have a rule and regulation that outlines really what is a commercial vehicle based on tonnage and usage and signage and things of that nature. So addressing issues impacting the community association that may not already be addressed. So, dealing with issues now such as charging stations, solar panels, satellite dishes, issues that just may not have been in your documents originally, or really in any kind of significant way. A lot of times we're working on things like leasing policies, leasing addendums. The documents may be silent as it relates to leasing. And then finally is, protecting the welfare of the community from damage and injury. So, it may be that you want something that clearly states that you can't set off certain types of fireworks or engage in certain activities which are harmful or dangerous to the community or other members. Things that may not be illegal anymore, but otherwise in a community setting could pose a threat of danger or injury to the community. So all of these and others are reasons why boards are often looking to adopt rules and regulations.
Just overview, some of these have been mentioned, but typical topics addressed in rules and regulations. You have leasing and occupancy restrictions, which oftentimes will take the form of a set of specific rules and regulations governing leasing of units. as well as an association leasing addendum that the board requires is attached to and incorporated into all the leases, architectural guidelines, vehicle and parking restrictions, collections and delinquency procedures, fine and enforcement procedures and policies, exterior decoration guidelines, pet restrictions, and also exterior maintenance standards.
And I'll just add to this, just keep in mind that, more is not necessarily better, right? We're not advocating that you adopt as many possible rules and regulations as you can. You basically, what you adopt, you want to be able to enforce and utilize. But some of these things specifically can be done in a way that protects the association, right? So a fine enforcement policy is going to help protect the association by giving you a basis to proceed with issuing fines. And so if you end up in court, the association is protected because you have a clear fine enforcement policy that provides for notice and opportunity to cure, things of that nature. So go ahead, Rob.
So again, like we said, the rules and regulations are kind of going to be the foundation for this. So to be valid and enforceable, a rule or regulation must not contradict any state or federal law, cannot contradict or conflict with any provisions in the declaration or the bylaws, also cannot be arbitrary and or capricious. Continued, it must be clear, unambiguous, and relatively easy to understand by unit owners and residents. Also, any amended or adopted rules and regulations should be circulated to the unit owners shortly after their adoption. And perhaps most importantly, the rule or regulation has to be reasonable. It's a big word in this portion of the presentation. It has to be reasonable both in terms of adoption and enforcement.
And let me talk about reasonableness, because you can very easily get into a situation where a rule and regulation is reasonable, for example, in a mid-rise or a high-rise, but is not reasonable in a single-family home setting, right? So if you want to mandate within a mid-rise or a high-rise that people must insert burst-proof hoses, have certain equipment inspected annually, water heaters, in order to ensure that there isn't flooding in the community that could impact multiple units, that's very reasonable. But if you have a single family home and you want to have that same requirement, it may not be reasonable because it's not going to impact anybody else. And so it's more directing on the use and enjoyment of their particular unit, but having no impact on the community. So you do have to take into account the type of structure and the type of community that you're dealing with in order to evaluate whether or not something's reasonable.
So as the reasonableness standard, there are essentially two categories. There's reasonableness in terms of the rules adoption. And what that generally means is that the board should be able to articulate a justifiable good faith basis for the implementation of a rule or regulation. And in layman's, in other words, really what that means is the board needs to be able to cite a specific issue or problem in the community that the rule or regulation can reasonably be expected to either address or help to avoid or prevent. As to reasonableness and enforcement, the rule or regulation has to be consistently and uniformly enforced throughout the entire community. And it also has to be reasonably capable of being uniformly enforced throughout the community, which again is a question that I think most boards should ask themselves, prior to adopting a rule is, okay, this is great, but are we going to be able to enforce this rule throughout the entire community?
Okay, and then does anyone have any questions?
And we will have time at the end, so no worries if nobody has any questions now, but you have them at the end. All right. So consistency in drafting, Rob, we can hit the next slide. So inconsistent enforcement is really one of the biggest issues that boards run into in terms of problems. And there's a number of different ways that you can get yourself into trouble with inconsistent enforcement. One is simply failure to enforce. When the association fails to enforce the terms of its own governing documents, either knowingly or inadvertently. And this is one of the areas that we often stress it's important for boards to be familiar with the governing documents, because those governing documents are really what you're responsible to be enforcing. So understanding what your rules and regulations are, what the provisions are within the documents, failure to enforce can create issues that we'll talk about next, such as selective enforcement, right? So if you're not enforcing them and all of a sudden you choose to enforce them, somebody could say, well, you're not enforcing them uniformly. You're enforcing them selectively. You're enforcing them discriminatorily. So failure to enforce can get you into a lot of trouble. Selective enforcement is similar in that sense that if you're choosing, I'm going to enforce it here, but this person's a nice person, I don't really want to enforce it there. This is a board member, we're going to give him a little or her a little leeway. You're going to run into trouble. Selective enforcement can essentially give someone the right to challenge the validity of your rules and regulations, and it can open up the association to claims of discrimination. So it is important to enforce that which you have. And one of the rules that I typically give boards that I represent is, basically have as few rules and regulations as you can, but those that you have, enforce. If you don't want to enforce it, get rid of it. Remove it. You have the right to remove rules and regulations. So if you say, we really don't want to enforce this, great, get rid of that rule and regulation. Okay, Rob. So board error can happen too, and this is sort of the inadvertent. We all make mistakes, and it's okay. We just need to be willing to acknowledge that and make sure that we correct it moving forward. So we don't want to compound the mistake of saying, well, we haven't enforced in the past, so we don't want to necessarily continue to enforce it now. The boards didn't realize it before, and now we don't want to. That's a mistake. If you have it on the books and you realize that it was not being properly enforced before, but you want it on the books and you want to enforce it moving forward, correct course and start enforcing it going forward. The other piece is lack of due process in the appeal process. So this has to do with the ability, ultimately, of the association to recover any fines that may be issued against the unit owner subject to the violations, right? Because it's one thing to have a rule, it's another thing to send somebody a notice of violation. But if they choose not to correct it, you want the ability to actually go in and begin to fine them in order to have them, correct and remove the existing violation. But you can run into trouble there if you don't follow the due process and the appeal process that's provided under both the UPCA and the UCA. So both acts provide that before you can levy fines for violation, you must give notice and an opportunity to cure. So that's important that be in the initial notice prior to levying a fine, so that when you start to levy fines, you know that the good thing about community associations as it relates to fines is they can become part of the assessments, and we can collect them as part of the assessments and recover attorney's fees and court costs in the process. But if you didn't give that notice an opportunity to cure, you may find yourself way down the road and not being able to recover all the legal fees and the fines and the costs that were incurred in the process. So due process and the appeal process is very important. Unofficial enforcement, we certainly see this from time to time. You have one sort of rogue board member who goes off and decides that they want to, sort of act on behalf of the board without board authority. I do fiduciary presentations for boards quite regularly, and one of the things I always tell them is that individual board members have no authority on their own. Their only authority really comes from the board. So you want to make sure that board members are not going out and sort of giving tacit approval or telling people they need to correct something without it really going through the process of the board. Same would apply to committee members and committees acting sort of independently, unofficially. So you want the actions of the board to be consistent, uniform, and official through the board. And then finally, governing document inconsistencies. You can certainly run into situations where you have a conflict in the documents, and that's going to create a problem for you in terms of enforcement, because you go to enforce something and the unit owner says, well, this provision says I can do it, your provision says I can't, why shouldn't I be able to do it? So you want to make sure that you don't have inconsistent provisions within your rules and regulations. And then finally, we have questionable or unsubstantiated violations. And this is sort of, Rob alluded to this before when he was talking about, the types of rules and regulations that you adopt as a community. And, I think often, boards have the best of intent, right? We don't want excessive noise. We don't want people violating stop signs and speeding. But keep in mind, you're not a policing body. You're not an enforcement body per se. So, you don't have officers out there inspecting and keeping track of traffic and things. So you would end up with somebody says, well, Joe over in 214 went through the stop sign. And Joe says, I didn't. So how are you enforcing that? So it is important to keep in mind when you adopt rules and regulations, how are you going to actually be able to enforce these things? And you then often do get into situations where unit owners have dispute with other unit owners, such as excessive noise violations. So just keeping that in mind when you go to adopt rules and regulations, it's one thing to have it, it's another thing to be able to effectively enforce it.
So with that said, we would like to go over just a few kind of what we think are best practices to avoid inconsistent rule and regulation enforcement. I think as Adam alluded to, make sure that all members of the board, any committee members are familiar with your governing documents. Just to ensure, again, if there are any conflicts, you can try to pick them out early. But again, just to ensure that everything is being correctly enforced. Ensure your governing documents have enforcement procedures that require notice and an opportunity to cure or to be heard prior to the initial levying of any fines. And then again, perhaps most importantly, ensure the governing documents are enforced in a consistent, uniform manner against all unit owners and residents in the community. Additionally, make sure the rules and regulations are up to date. Board may wish to look at them, after a certain period of time, just to make sure that everything in there is applicable to the current community. If there's something, for instance, let's say EV chargers. I think Adam brought up earlier is a good example of just how times change, and so boards should ensure that rules and regulations kind of change with it. Also, very important, stay in your lane. And what that means is that board members and committee members should ensure that they're acting within the scope of authority that's granted to them under the act, or the governing documents. And then ultimately, any decision that the board makes, kind of the last question it should ask is, whether or not the board reasonably believes that the decision is in the best interest of the association and its unit owners, and same is true in terms of the adoption of rules and regulations.
And just before Rob goes on there, just talking a little bit more about updating rules and regulations. This is really important. It's important to keep, looking at them. They're sort of a living document. You want to make sure that they're current and being updated. There are changes that happen often in the Uniform Planned Communities Act, the Uniform Condominium Act, new state laws that come out that may impact communities, new ways of handling things that should be looked at. A lot of communities do establish rules committees, sort of to get a wider input into that process, so that you sort of get more buy-in, that more people are involved in the process. Ultimately, it's usually for the board to approve those rules and regulations, but often getting additional people involved, depending upon the size of your community, obviously, can be beneficial in terms of making sure that you get that buy-in of the community, and that it's what the community wants to see this as well, as just not just the board. All right.
Okay. So. Further best practices, make sure that the board, property manager, committee members documents everything. Maintain detailed documents or records of either unit owner complaints of alleged violations, include dates and times and any other evidence that supports the alleged violation. Again, one of the reasons that we recommend this is that if fines are levied and then challenged, we end up going, we end up having to go to court. It'll just help support the association's position if you have, as much information as possible. Also, witness testimony, other unit owners, document, maintain detailed records of any testimony provided to the association describing a potential violation. In certain circumstances, witness testimony can be very helpful in terms of those proving those violations that are otherwise tough to prove, such as excessive noise, things of that nature. Photographic evidence, depending on the nature of the alleged violation. If you can obtain photographic evidence of the alleged violation, that's great as well. Examples are property damage, parking violations, certain pet violations as well. Also, in any instances where community leaders, board members, committee members, property managers are unsure, it's okay to reach out to the association's professionals. So for instance, if the board's unsure about a potential violation, certainly recommend reaching out to legal counsel prior to initiating an enforcement action, just to make sure the association is doing everything correctly. Example, unit owner violates a pet restriction, but claims the animal is an emotional support animal. Should the board immediately initiate an enforcement action or contact legal counsel? I was gonna let anyone chime in.
Would anyone like to answer the question? You can unmute. Okay, I would say contact legal counsel.
That is correct. Yes. Especially when it involves an emotional support animal. And then Adam alluded or mentioned this earlier, that boards are encouraged to work with legal counsel to implement and continue to keep up to date fine and enforcement policy, that it would be applied uniformly and consistently in the community. We find that fine and enforcement policies can help to ensure that there's no ambiguities or uncertainties as to the processes and procedures relating to enforcement actions, and that goes both ways. Not only for the board, but also for unit owners, because after a fine and enforcement policy is adopted, board should circulate a copy of it to everybody. And again, it helps to make sure that everybody is on the same page.
And I'll give you one more piece about why the fine enforcement policy is so important. Typically, fine enforcement policies include not just a single fine for a violation, but often a per diem for something that's a continuing violation. Because, if you have a unit owner, if you have a no leasing policy and a unit owner leases their unit, and you simply have in your governing documents, it says that that's a violation and violations are subject to a fine of $100. Great. You fine them $100. They say, great, here's my $100. They continue to lease the property, right? What's the incentive for them to cure it? So now, you have to take an enforcement action potentially to enforce the governing documents filing an action in the court. Otherwise, if you had a good fine enforcement policy with a per diem, they'd be accumulating a per diem fine that could amount to close to the rent that they're getting and really negate the financial benefit for them of doing so. So having that, makes the fine enforcement policy much more effective to be able to actually enforce these things. Because ultimately, the rules and regulations are there to protect your community, to protect the aesthetics, to keep people safe, to keep property values. And you need to be able to enforce them if you actually have to. So a good fine enforcement policy is one of the most important documents that a board will adopt by way of rule and regulation. All right, conflict resolution, dispute management, and community associations. Go ahead, Rob. So generally, this is about the process for addressing and resolving disputes. And we're going to talk sort of generally about this in different ways. But, the three basic types of disputes that you can have that may require some resolution are disputes between unit owners, disputes between unit owners and the association / board, really the association generally, and disputes between current board members. And, boards are responsible for the administration, the management of their association, which can, and the reason, that asterisk is there is because it's not always, include resolving certain conflicts. Some conflicts you don't want to be involved in. Some conflicts you cannot resolve, and we'll talk about some of those and what they look like. So it's important when you have disputes between unit owners initially to investigate, so you have an idea of what's really going on here, because that's going to help you determine whether or not really it is a matter that the association wants to be involved in. If it is a personal dispute, so-and-so is harassing me, so-and-so is saying things that are inappropriate to me, or it may involve two people within a unit or family issues or something like that, that is really beyond the scope of what the board should be involved in. Certain personal disputes you don't want to be involved in. And so that would be beyond the scope of what the board should be participating in or trying to help resolve. Criminal matters. A lot of times unit owners will contact the association of the board and say, so-and-so is committing a crime. Well, don't call us, call the police. That's you absolutely always want to direct someone to the authorities if there is a criminal matter going on or something that they believe is arising to that kind of a level. It's way beyond the scope of what the association should be involved in. Board members shouldn't be going over to unit owners' houses to try and resolve those types of disputes. They should always call the police. Disputes that are impacting the community is often where the association gets involved. So when you have violations of the governing documents, that's something typically the board wants to get involved in. I was once involved in a dispute between two unit owners that involved sound, and it was a constant thing. The units were stacked, so one unit was on top of the other. And the unit below said the unit above is making a racket. They're jumping, they're making all this sound, and it's interfering. And there's a provision within the declaration that says you can't interfere with the use and enjoyment of another unit owner's property. So there was a specific provision within the declaration. And so the board had to be involved in it. We actually had a hearing on the matter. I was there sort of acting as the judge to help the parties present their cases. Ultimately, the board had to render a decision. But, that's one where it's even though it's between two unit owners, it is involving a specific violation of the governing documents and therefore appropriate for the board and the association to try and resolve. So, basically just the takeaways from what we just talked about, you really should first determine when you want to intervene. Is it appropriate? Is it involving a personal matter or a criminal matter, or is this actually involving something that the association should be involved in? Always important to make that initial decision before you dive in and sort of get the association involved in a matter that ultimately then you want to extricate yourself from because you shouldn't be involved in.
So doesn't happen all that often, but occasionally, we have disputes between board members. So one of the most important things that the board as a whole should try to keep a united front. There's an old saying, attitude reflects leadership. So, when you're elected to the board, you are essentially being elected as a leader of your community, your association. So it can be difficult when there's disputes between board members, because if it starts to kind of leak out into the community, it can result, in it creating doubts in unit owners' minds regarding the effectiveness or the intentions of the board and management. So again, if there's any internal disagreements, that's fine, but try to keep them internal, just amongst the members of the board. Also, again, back to that leadership position, as elected members of the board, directors should strive to set a good example for all other unit owners, especially when disputes arise with other members of the board. Again, try to be willing to discuss and compromise with one another. And most importantly, in resolving conflicts between board members, Each member of the board should always keep in mind that they have a legal fiduciary obligation to act in the best interests of the association and its unit owners.
And I'll talk about that just for another brief minute, because fiduciary duty is really the most important thing that you keep in mind, right? It's what protects you as board members. If you're meeting your fiduciary duty, you're protected. You have limitation of liability under the act, under the governing documents. You're protected if somebody sues the association. But with that comes a host of conditions and requirements. And one of them, for example, is a duty of confidentiality. So, you have a duty to keep confidential. And one of the, actually positive things, I know a lot of people sort of in the community association world have been trying to get associations to require them to have open meetings, right? Like sunshine laws that exist for municipal governments. It does not apply to community associations. And actually, there's a good reason for it, in my mind. And that is that, you want boards to be able to have really open discussions. People raise their concerns. If you're talking about big issues that are affecting the association, be able to everybody put their 2 cents in and to have an active dialogue between board members. But ultimately, you have to remember that decisions of the board are made by the board. And so a majority of the board makes the decision, and that's the decision that everybody has to go out and follow. And if you're going out and you're conveying information of those meetings to other people, not only, is that going to create a dispute between board members, but it's really potentially a breach of your fiduciary duty because you're not acting in the best interest of the association. So resolving those differences between board members at the board meetings and at the board level instead of at the community level is really important for the association. All right. So, a lot of this is I think, pretty straightforward. Keep calm. Community leaders should remember their position in the association. I'll give you an example. Keep calm and stay professional. I've attended many community associations over the years, and some of them get quite hostile depending upon the issues that are being discussed. You often have factions and people coming with their issues, and they consider this their opportunity to let the board know how they feel and express themselves and take their position. Maybe it's frustration with the board and the actions that the board has taken. The biggest mistake I've seen board members make is when they lose their professionalism, they lose their calm, and they engage with the unit owner in the same way the unit owner is engaging with the board member. It is not helpful. It is not beneficial. It does not resolve issues. It escalates issues. So, keeping that in mind, especially at open meetings, annual meetings, it's the board at the front of the table, at the front of the room that really sets the tone for how these issues get resolved between the association and unit owners. And, listening to the community, I have boards often that say to me, we don't want to do this. And I say, well, look, if 75% of your community wants this, don't you want to know that? There's some value in knowing what your community is looking for. And so listening to them is important. Keeping hostility in check is pretty straightforward. Being open to compromise is just simply a part of the listening process and understanding that, really the best communities are the communities that operate as a community. And that word community has significance, right? If you think about what is a community, it's a group of people that come together. And, you're not going to get consensus on everything. One of the things I sort of joke is I had one association that had a 90% approval requirement for amending the documents. And they came to me and said, we want to amend the documents. I said, you're never going to be able to amend your documents. You can't get 90% of a community to agree upon something. So, you have to be open to some level of compromise ultimately as a community association.
So just to begin again, some general steps in terms of resolving conflicts and managing disputes. One of the first steps, refer to any internal conflict resolution procedures. A lot of governing documents already have provisions, establishing, how to proceed if there's a conflict or a dispute, either between 2 unit owners or a unit owner in the association. If the governing documents are silent on the issue, board members may wish to work with legal counsel to prepare one which would be, you know, authorized under the board's rulemaking authority. Again, if whether any processes are already in existence or if you create one, you need to ensure that it is consistently adhered to once it's formally adopted. Also, again, similar to just a general rule or regulation, having clear and concise, you know, rules for conflict resolution is key to ensure that the process goes smoothly, that everyone can understand it, regardless of what the underlying dispute might be. Also, effective communication can be, you know, very key between the parties, just to help to ensure that conflict resolution, you know, proceeds accordingly. Layman's terms. I find this very important. And again, I'm certainly guilty of this as an attorney. But in communicating, you know, with unit owners who have issues, it's definitely helpful to use clear, simple, you know, non-jargoned terms that, you know, that everyone can understand. Also, keep any communications between the parties, you know, as short and sweet as possible. Focus on facts, outline, you know, the terms of the association's dispute resolution process, or whatever the applicable provisions are in the governing documents. With the longer it is, the response or communication is, the higher the likelihood of a misunderstanding or that the individual receiving it just won't digest all the information. Whereas keeping communication short and simple helps streamline the process, keeps confusion to a minimum, and promotes transparency, you know, between the association and the unit owners.
All right. Generally speaking, when you have a dispute between two unit owners, you're trying to be neutral. You're right. Either there's a violation, there isn't a violation. You don't have skin in the game. You're not trying to prejudge it. So neutrality between those disputes is important. There are times where you're going to want to seek professional guidance, you know, in terms of dealing with the conflict. So the example that I gave before about the noise dispute between the two unit owners, in that case, the board just felt like they were holding an official hearing. They wanted legal counsel to come in to basically run the hearing because none of the board members were attorneys. They just didn't feel comfortable sort of running it as a hearing that would be. So sometimes you do want to get counsel involved for something like that. And then ultimately, you know, you keep documentation for the disputes, and it helps protect the association because if there is a dispute involving a unit owner and they challenge the actions of the board, they believe it's selective enforcement, they believe it's discriminatory or anything else, having the documentation to be able to support the actions of the board moving forward is always a very helpful thing.
So, in addition to potentially being in the governing documents, both the Condominium Act and the HOA Act, 5321 and 3321, both require that certain associations created after, there's a reason why it's up there, July 3rd, 2018, adopt bylaws that contain specific procedures for alternative dispute resolution between either two or more unit owners or a unit owner or multiple unit owners in the association. Under the acts, however, any such dispute resolution process is limited to disputes where all parties agree to go through the alternative dispute resolution process. Also, both of these provisions provide that the costs and fees associated with the process as incurred by the association, excluding attorney's fees, would be assessed equally against both parties to the dispute, regardless of whichever party is ultimately, I guess, what would be characterized as the winner. Again, some limitations there under the acts. It's the only associations created after July 3rd of 2018 are obligated to include an alternative dispute resolution process or procedure in their bylaws. So any associations created before that date, they may include an alternative dispute resolution process in their bylaws, but it's at their discretion, and doing so would most likely require an amendment to the bylaws. Also, these provisions in the act are limited in their scope as they apply only to disputes between two or more unit owners or a unit owner and the association, not intended to cover internal disputes that might arise between board members. And then also all parties to the dispute have to agree to engage in the alternative dispute resolution process in order to even, take this road.
Does anyone have any questions? I don't see
Yes, I
anything.
do. I do.
Okay.
I just have a question back in the very beginning where my association is in the process of updating all of our documents because they're so old and a mess.
Yeah.
And in order for the declaration and the bylaws to be changed, you have those percentages of owners that have to agree to it.
Yes.
We have a history here of anything we try to do, we have a very hard time getting unit owners to respond at all. So
Yes.
what happens if we can't get the percentage needed?
So, right. So it's a challenge. It's a challenge that you are not alone. Many associations have this challenge. I'll answer your question in a sort of a roundabout way, but I represented a community that was the exact same position, wanted to do a big overhaul. Their documents were very, very outdated. And they did they created committees and they spent a year putting together an amended and restated declaration, bylaws, and rules and regulations. And they put it out to the community, and the community voted against it. A lot of people don't like change. And so you do have to try and work to get buy-in. That's what I was talking before about sometimes getting, a rules committee together to get people on board and sort of to buy into the process. But to answer your question, simply put, if you can't get the required percentage to amend your declaration and you can't get the required percentage to amend your bylaws, you can't amend those documents. That's it. You can, as a board, amend your rules and regulations so long as they're not in conflict with those two documents, but that's the only set of documents that falls under the purview of the board. The only exception to that, I will tell you, is what's known as a technical corrective amendment. Both acts and most governing documents provide the association with the right to do what's known as a technical corrective amendment, either the declaration or the bylaws. And that technical corrective amendment, in order to go through, is usually because there's a conflict in the documents, an ambiguity, you need to conform to Fannie Mae or Freddie Mac, something of that nature. You go to your legal counsel, you get an opinion letter from legal counsel that says, yes, this qualifies as a technical corrective amendment. And then the boards can proceed with a technical corrective amendment, which does not require unit owner approval, but it's a very narrow, limited exception. Otherwise, you need unit owner approval to amend your governing documents.
So you basically go and knock on everybody's door and say you need to vote yes or no.
That's exactly right. You're dead on. That's often what I tell boards. They're like, what do we do? I say you go door to door. You get people out there to try and get people to sign on to it. You extend the time period within which you're voting on this to give the board enough time to go out and get all the votes that they need to.
Okay, thank you.
You're welcome.
Okay, does anyone else have another question? Okay, can I ask a question?
You certainly may.
Okay, so I have a community, so they have a tenant that is revving their engine in the early morning and late at night. I guess it's been happening for a while, but now other homeowners are complaining about it. He is a tenant, so he's not the unit owner. What steps can the board take for that?
So regardless of whether it's a tenant or a unit owner, normally, again, this is without seeing the governing documents, knowing what the rules and regulations are, you're setting notices of violation to the owner. Now, some associations will have a leasing addendum. So we often work with associations that have leasing policies where they adopt a leasing addendum that requires both the tenant and the landlord to sign that at the time that the lease is signed. And that leasing addendum does give the board the right to take certain action as it relates to that tenant, including sending them notice of violation directly. Sometimes some boards even want the right to pursue eviction of tenants. Those are sort of extreme cases, but there are certain circumstances in which that can happen. But generally speaking, without that, you're sending a notice of violation to the unit owner and then fining the unit owner for any violations that may be being committed by the tenant. And then the hope is that the landlord, the owner of the property, will do something to get rid of that tenant or take action against them as a result of the fines that they're having to pay to the association. Now, that's another reason why you also potentially want a good fine enforcement policy, is because fine enforcement policies under the governing documents, you can, in certain circumstances, revoke certain rights of unit owners and tenants with respect to access and use of facilities. So you may be able to exercise certain additional rights to limit access to, clubhouse or other venues within the community, so long as there's an ongoing violation outstanding. So that's another avenue, but again, that's through a fine enforcement policy.
Okay, thank you.
You're welcome.
Does anyone else have any questions? All right, and I don't see anything in the chat.
Well, before we wrap that, just really the biggest takeaways that I'll tell you to take from this, the fine enforcement policy. That is one of the most important things for an association to have. Secondly, have as few rules and regulations as you can reasonably and enforce those that you have on the books. And then finally, do so uniformly and consistently across the board. Those are the best sort of final piece of advice I can give you to sort of keep boards out of trouble.
Okay, well, thank you, Adam, and thank you, Rob. Thank you, everyone, for joining. We will have this recording link available for any board members who could not join by request. The next board event will be on February 12th at 6 p.m. and the topic will be reserve study and capital project planning. Thank you.
Thank you. Take care, everybody. Have a good night.